difficult for people to get back their monies. But then there are people who aid them. And who are the people who aid them? The people who aid them are financial houses, they're banks. And these solvent persons are persons who generally, as you will see, they continue to do it because it's profitable for them. Profitable in the sense that they can get away with it. So when we talk about financial crimes, you find that the banks are usually the intermediaries, the ones who do all the businesses for them. And because they do all the businesses for them, the banks will continue to do it because it pays them to do so. So why go against insolvent and bankrupt criminals when we can go against the solvent ones, which we call the banks? So basically, today's webinar is all about how we can directionally change how we fight financial crimes. Rather than using the criminal system, we can now begin to use a civil arsenal. And if you look at slide number 5 tells you exactly what these arsenals are. And these arsenals are provided under civil remedies. The arsenals are arsenals of injunction. And then I use the word metaphoric analogy. That is, by extension, we're looking at how we can use which are analogous, as it were, to provisions of fighting crime. If you read your section 7 or so of the criminal code, it does provide that those who aid, those who abet, and those who are principally partake in the offense are all principal offenders. So Equity has been able to design what we call receipt-based claims and knowing assistance nets with which we could catch these fraudsters who engage in financial crimes. And of course, the modern law of restitution has gone further to fortify these constructive trust principles of receipt-based claims and knowing assistance under some form of restitution. Basically is what we used to call quasi-contracts. So there's restitution for unjust enrichment, there's restitution for acquisitive wrongs, and there's restitution for the vindication of property rights. So we're going to be looking at how all of these arsenals can be deployed against fraudulent persons. We'll start by looking at slide number 6. There are 3 cases that are listed there. The 3 cases are the Mareva case, of course, which provides that an authority that says before the 1975, it was impossible, as it were, to arrest the assets of a fraudster or a person who is an unscrupulous businessman. Of course, you agree that an unscrupulous businessman is a person who trades and traffics in dirty money. But in the Mareva's case, the court did hold that it is possible to bring an application to arrest assets which are standing at credit in the bank account of a fraudster. And of course, once assets which are in credits in the bank are arrested, what happens? Once the criminal cannot access his money, the first thing is likely to do is to settle. And then, of course, the Supreme Court in Shotin Minu and Ocean Steamship says that's part of the Nigerian jurisprudence. But very interestingly, the case of Lipkin Gormack is an interesting case in England because that's the case in which the House of Lords many years ago, before it became the Supreme Court of England, expressly and explicitly recognized restitution as part of English law and arsenal. I'll tell you just the brief facts of what happens in the Lipkin Gormack case. Lipkin Gormack was a case where the solicitor stole over £300,000 of the partnership monies which were kept in a bank, and he used the money to gamble in a place called Playboy Club. So the partners could not recover all the monies from him. So what they did quickly was to launch an attack against Barclays Bank, where the monies were. They said Barclays Bank is a knowing assistant in the sense that the monies were kept there in the bank. First, monies which are standing at credits, they were able to place a trust on it to say that monies which are standing in our credits before a bank are monies for which the bank owes to pay us, and therefore they are also stuck with what we call fiduciary or trust monies. If those monies have moved away from the bank, it means that the trustee had aided a criminal to steal the money. And how did that happen? That look, there are 5 levels of knowledge which are required. and that a trustee must exercise due care. What are these knowledge? What are these thresholds of knowledge? Actual knowledge, that of course the bank had actual knowledge that the man was stealing money. Of course, the bank denied that. They say, well, if you deny that, then you must be willfully shutting your eyes to see, because the man was withdrawing so much money in such quantum and currency that you should have been put on a trail of investigation. And then, of course, the third is that when a man fails to make a reasonable inquiry that a reasonable man would make, they said the bank did not make reasonable inquiries, or that the circumstances were such for which they should suspect that something was going on wrong, or that there were circumstances that would have called upon the bank to inquire, that those thresholds of knowledge were sufficient to put the bank as a person who knew what was happening and was assisting a fraud, as it were, of the lawyer who stole the bank's money. They didn't stop there. They launched also some form of complaint also against the gambling club where the monies were spent in gambling. They said, look, our monies have come as trust monies, and the monies are found in your hand. So there's a receipt-based claim against you. And of course, you know you are somebody who has knowingly received, of course, using the 5 basic knowledge tests in the case of Badex, which is slide number 7. Of course, they said, look, we don't know anything like that. They said, well, even if you don't know anything like that, you must have a juristic basis for receipts of monies. Otherwise, you'll be liable. And what happened? Of course, they had no juristic basis for it because the monies were spent in gambling. Gambling, of course, you know, is an illegal contract. So based on that, they've succeeded against the gambling club. So how can that really work in an empirical case? Let us see how we say it can work in an empirical case. Here is a victim. He's the victim of a fraud. He has monies in his bank account, and the fraudster says, send me so and so sum of money. He sends that money to the person. First, his bankers are holding his monies, and such monies are ratified as trust monies because the bank is under a duty as a trustee to give him back his money because they are credit balances to him. So first is an attempt to follow his money to his bank. What he does, he places a trust on the money. That money has left his bank and has gone to the bank of the fraudulent person's account. The fraudulent person is there. His bankers are also there. His own bankers that transferred the money are there. So there are 3 persons whom he can launch an attack against. 1, his own bank. 2, the bank of the fraudulent person. 3, the fraudster himself. So what can he do with his own bankers? First, he can show that the money in his bankers' hands are trust monies which have left his bankers. Now, if that money is still in the bank, the receipts bank, that's the fraudulent person's bank, then he can bring what is called a receipt-based claim. As long as there is a balance, he can equitably trace or use restitution to recover back his money. And how does it go? It goes about it by saying that, look, trust money is in your hand, you are receiving trust monies, the monies are still in your account, return such money. In fact, in the Lipkin-Gomax case, the House of Law seemed to say that even tracing iniquity can be equated with restitution law for vindicating property rights and make it a strict liability offense. So the bank, the fraudster's bank is under a duty to return the money under a receipt-based claim. But if there's no bank balance, for example, let us say there's no bank balance, the fraudster had taken all the money and has run away. That's not the end of it. They can still launch an attack called knowing receipts, that is knowing assistance. Assistant in what way? Assistant in the fact that you must know your customer. If your customer brings in so much sums of money at so and so period of time, you come under a duty to investigate because a reasonable man will investigate why monies are coming in from so and so thing. So these are empirical ways at which we can fight financial crimes using civil law remedy. And that is why I've said lawyers need to learn how to skillfully, if you look at slide number 8, that they need to learn how to synergetically reason that bank balances are monies which are held by fiduciaries, and therefore they are traceable balances which can be followed to the hands of the fraud or to his bankers. And his bankers can, if they have the balance, they can stick them with knowing receipt claim based. If they do not have it, now, as it were, devise a means to show that there's a knowledge requirement, and that to the extent that the bank did not make such inquiries that they ought to make, then the bank also comes under some duty to make restitution. Now, I have looked at slide number 9. Slide number 9, you begin to ask the question, is it possible to mix basis from equity to trust? Yes, and yes is the answer. And even from there to common law. In fact, in Anderson and Merit Syndicate is an interesting case, which I commend that lawyers read. It takes you back to the history of what we call indebitatus assumpset, which allows a remedial mixture between contracts, tort, restitution, and equitable obligations. And the Nigerian Supreme Court in International Textile Industries Limited and Aderemi, WIFO says concurrent remedial regime, of course, is permissible under a civil law system. Now, that takes me to slide number 10, which basically has to do with a global money trail. Of course, the African continent keeps complaining that all of its money is run away and the monies are deposited outside this country. Well, the case of Republic of Haiti and Dovela shows how skillfully lawyers have been able to use injunctions and principles of restitution to track money, dirty monies all over the world. What happened in the case of Dovela, Republic of Haiti and Dovela? Dovela was the president of Haiti, and they call him Dr. Dieu. He stole from accounts of the Republic of Haiti over 120 million US dollars. And the monies were lodged in several accounts in the Channels Island, in France, and several other places. So what the Republic of Haiti did was to launch an attack, a suit against Dovela in France. And this lawyer, of course, stole some of the monies, took the monies to England and deposited them in England. So what the Republic of Haiti did was to bring an action against Dovela in England. And the action that was brought was not an action to even recover. It was just an action to preserve that money in the event that there's a preemptive injunction. So they brought a Mareva order injunction against Dovela. And the question, of course, was that Dovela's lawyers argued that there was no action and that an injunction was being in support of a substantive action, and that since injunction was only sought for as an only and final remedy, the Republic of Haiti did not have a good claim. Of course, the English court said no. Under a Brussels Convention on Jurisdiction and Enforcement of Judgment, Civil and Commercial Matters, 1968, it makes it possible as a signatory to the convention can arrest assets anywhere in any of the member states that are signatories to it once an action, a substantive action is filed in a member state. So what they did was to arrest these assets that were in England. And in fact, the judge went as far as to order a worldwide Mareva order and a disclosure order against all the assets of Dovela anywhere they are found in the world. So I have also suggested that if the African continent is interested in fighting money, dirty, illicit monies that flow away from Africa, then we can draw up something that looks like the Brussels Convention and then ask our European partners and brothers to sign. If they sign, all we need to do is, if Mr. X steals Nigerian money and the monies are found in America, all we do is to launch an attack against his money, against him in America, and then come to Nigeria and just ask for an injunction. An injunction prevents him from getting this money. And once a man does not have money, he can't pay his lawyers. He does not fight. He comes on his knee and is most likely to settle. So these are some of the remedies we can begin to use at the individual level and at the global level to fight dirty money. I've also cited an interesting case, which is this case of the Securities and Investment Board versus Pantel. That was an interesting case that shows that even rights to sue, to recover for restitution and also for injunctions can reside, as it were, with government officials. That was a case where some guy brought some scheme from Germany to some English people about some pony companies that were in America. Of course, the shares were bought and it was found that the shares were all pony companies. But because they were all small holders, the Secretary to State now brought an action for the recovery on their behalf. So I'm also saying that we can tweak our investment and security laws in such a way that we can have either the Attorney General or the Minister for Economic Development stand in proxy to sue for and on behalf of persons who have been defrauded and who are too small to fight criminals, especially if the criminals are sophisticated transnational criminals who engage in financial fraud and crimes. So I've said there's a need for lawyers to learn about the principles of knowing receipts, knowing assistance, how a Mareva injunction can be used in a worldwide scale, and also to learn more about the modern law of restitution, particularly those aspects that are restitutions for vindication of property rights. When lawyers do this, and we can bring some successful action against banks as knowing receivers or as persons who knowingly assist, I can tell you something. If any bank loses so much money, the bank itself will breathe down heavily on its managers. Recently, I just saw one of the banks that says if you lose your card or something, your POS card, you can quickly dial a particular number so that you can stop all transactions. That's because they have found that people are going against them and they are recovering from them, even though they have not really tested it in court. But once we test it in court and a bank is under a liability to pay hundreds of millions, of course, bank managers will be the ones themselves who will tell the criminals it's no longer business as usual. You can't do all of this here anymore. So that way, we can reduce, if not eliminate completely, financial crimes in the Nigerian legal system. So thank you, gentlemen. These are remedies which I say we need to explore. And lawyers must be in the forefront of this, but it requires synergetic thinking. So let lawyers continue to do so and show that they have become remedial experts in fighting commercial crimes using civil law procedure and not just using the EFCC, ICPC, and several others. It's nice to be with all of you, gentlemen. Good afternoon very much. Thank you.
Thank you very much, Prof. We have some questions that have come in. It's good for us to know that besides the criminal remedies that are available, there are civil remedies that we can explore as private citizens. But there are a few questions that have come in, and these questions are questions that are very related to some of the issues that we've discussed, and we just picked them and would like you to address them. One of them, I think this came up as we're discussing earlier, is someone is asking, can this civil law remedy be instituted along with criminal law remedy? So can you have a criminal proceeding going on and one can still be able to bring the civil proceeding together with the criminal proceeding? Another question that goes with that is, what is the relationship between the rule of double jeopardy and this? So if someone has been convicted in a criminal proceeding, can one equally also institute the civil proceedings against such an individual? Prof, do you want to take those questions, or do you want me to?
Let me take them. Let me take the two. Let me take the two first. I'd like to say quickly that concurrent legal remedies is permissible under the common law legal system. There can be civil remedy. There can be civil suits while the criminal suit is going on. The case of Lipkin Gomak is first before I go to statute. That was a case where, of course, if you read the case, you say they recovered against Cass, and who recovered against him? The solicitors recovered against him. After having recovered against him, what did they do? He was sent to jail as a lawyer, and the partners, of course, still proceeded against the banks. And don't forget, we're not going after this. We're not going even against the fraudster, because the fraudster may himself just be bankrupt. But we're looking for solvent person, the banks, the places where the monies are spent. Like you see in this case, it was spent gambling in Playboy Club. So I think you can even say right away that there's nothing like double jeopardy, because one suit was against the criminal who is gone to jail, second suit is against the bank, and then the other suit is against those who have received it. So that's clears it out. And what is more, if you look at the Administration of Justice Act, it even allows it. It allows that you can also in a criminal case seek restitution. But restitution against the person who is a fraud. But we're not looking at the person who is a fraud. We are looking at the intermediary between him and the victim. And that's usually the bank. That's what we're looking at. Does it make sense? Yes, Mr. Raf.
Absolutely, sir. Absolutely.
Yeah.
Thank you very much.
Yeah.
There are other questions that have come in also that I would like you to address.
Very well.
One of them says, your reference to proceedings against criminals suggests that there must have been a conviction of those persons before the civil wrong can be explored. What's your answer to that? Must there be a conviction first before
not unnecessary
proceedings can be explored?
We are looking from what we've just said. We're looking at a situation where the criminal is not even found, but we know his bankers. So our target is not against the criminal. Our target is against the bank that he uses. If the monies are still lying in credits in the bank, we're asking for a right to receive it back by tracing it as balances, because we're using a receipt-based claim. If there's no balance with the bank and the man has withdrawn all the money and spirited away with it, we're chasing the bank as a person who has knowingly assisted a breach of a trust or fiduciary. That's where, so please make a separation, make a conceptual separation and practical separation between the criminal and his banker.
Thank you very much, sir.
Yeah.
Now, the next question says, what institutional challenges in Nigeria can truncate the recovery of stolen monies and assets, especially as it relates to money asset tracing? Are there institutional challenges?
The first institutional challenge is a lawyer. Our lawyers are yet to even understand. I'll tell you, some years ago, when I was a teacher in Lagos, a student of mine went to one of the very big farms in Lagos, and she said she wanted to do some work for NYC there. And I remember, she told me this story. She's in Canada now. And she said, the big lawyer, I won't mention his name, because if I mention his name, you all know him, said, look, you can't add anything to us. We know everything here. And she said, no, this what I'm telling you is a story of some 18-year story now. And she said, yes, there's something I can add to this partnership. And he said, like what? He says, I will help this partnership to talk about knowing receipts and knowing assistance. And the senior most partner said, come in and sit down. What have you just said? Knowing receipt and knowing assistance. What does that mean? And she said she explained it. And immediately the senior partner said, you have a job right now. We're employing you here, even after your service. So the truth about it is that most lawyers do not know that these remedies exist. So that's the first institutional challenge. Two, then the lawyer would need to understand that bank balances are itself monies that are held by fiduciary. That requires a synergetic thinking through the cases, looking at distinguishing between property, which is empirical, and property, which is abstract. That is, properties which are not capable of manual seizure, but are themselves also property, and therefore there's a right to recover them. So that's the first challenge. Once you go through that challenge, then it will be a challenge to convince judges that this is how the law has developed. For example, when you talk about indebitatus assumption, I'm very sure many lawyers don't even understand it. Lawyers don't even understand that torts first existed before contracts, and that contract grew from the intestines of tort. And that is why most remedies for breach of contract is now said to be damages, because that was the only remedy which was available in torts under the doctrine, under the concept of indebitatus assumption. So there's a need for lawyers to learn some things about legal history so they can see the origin of remedies. Unfortunately, remedies are not taught in any of the Nigerian universities. So lawyers need to learn by reading properly. Once they conquer that, then they can place the arguments before judges who will buy it. I can tell you that.
Okay, we see the concerns raised about the slides. We apologize again, there have been a lot of technical issues, but the slides are going to be emailed to every participant. So if you registered or if you're participating, you're going to get the slides immediately this is over. Also, Prof, someone is asking that all the cases that you've mentioned seem to be foreign cases, mostly British cases. Yeah. Are there no Nigerian cases? And how would Nigerian courts treat this precedent? Would they just be persuasive, or considering that there are no Nigerian precedent or seemingly no Nigerian precedent on these issues, do you think this precedent will weigh heavily on the mind of the court?
I'll start by addressing the case of the Mareva injunction. Before Mareva was invented in 1975 in England, there was no Nigerian case of it. But in Shotomini's case, the Supreme Court was persuaded by it and said it is properly part of Nigerian jurisdiction. Henderson and Mary Syndicate is an English case, but I've also cited the International Textile Mill case and Aderemi. So read them up. It shows that the Nigerian judges are beginning to, we have not brought these things before them. No one has raised. If you go through the law report, I've taken time to go through all our law report from 1956 to date. There is no case on knowing receipt or knowing assistance. Someone has to start it. And if you must start it, you must have an analogical basis for starting it. That's why we say analogical reasoning means this is what happens elsewhere. This is how it should be here. So it's a question of analysis. Someone has to do it as a pioneer.
Thank you very much, Prof. Now, the next question is, would this concept not be affected by the criminal law requirements of strict liabilities for criminal wrongs? Strict liability?
Well, there can be no strict liability for criminal wrongs, but I've just said that if you look at how the cases are developing, not only in Nigeria, but also in Canada and in Australia, in all of these countries, you will find that there's synergetic thinking, and all of these jurisdictions are moving in one direction. That Nigeria has not moved in that direction is a show that our jurisprudence is yet to develop, and it will take lawyers' thinking and energy to develop the law. So we are calling, these are what we call them emerging principles. For example, when we talk about restitution law, restitution has always been part of the Code Napoleon, which had always existed far back in the 18th century in France. All civil countries know it. But it was not until 1991 that England explicitly recognized it. It was not until 1993 that Canada explicitly recognized it. Nigeria has not. And we're looking for some lawyers who will bring cases before the courts so that the courts will now begin to recognize them. So we're saying that our jurisprudence should develop along these lines.
Thank you very much, Prof. We are taking these questions as they come.
Yes.
And there's another question that is asking if you need to prove the criminal elements in your civil case. So would you need to prove the mens rea when you want to prove your case in a civil suit of this nature? Do you need to prove mens rea? You need to also prove that there's actus reus. So the criminal elements, are they relevant to this nature of suit?
Okay. Let me say what is relevant here is knowledge requirements. And the knowledge requirements in the case of Badex have been split into 5. And what are this knowledge? It includes actual knowledge and constructive knowledge. One, just like we talk about actual knowledge. If they have actual knowledge, of course, they are liable. If they do not have actual knowledge, but they have what we call they willfully shut their eyes, because if they open their eyes, they will see what is happening. That also is imputed knowledge. Also, failing to make inquiries that a reasonable man would make also is knowledge. Failing to suspect what a reasonable man would suspect because of the circumstances of a dealing is knowledge. Failing to inquire because circumstances are such that call for you to inquire is also knowledge. So you can see that the knowledge we're talking about for civil proceedings is the threshold is lower than the knowledge you talk about in crime. For crime, you must have actual knowledge. But for accessories liability in civil law, the knowledge does not have to be actual. It can be imputed knowledge, as long as it is some threshold that shows that there are circumstances that should make a man to suspect or to inquire, and the persons did not inquire and did not suspect.
Prof, thank you very much. The next question is going to be our very last question for this session.
Yeah.
And the question is, okay, I see a lot more questions coming in. We're going to respond to them by email mostly. Or Prof, would you still be able to take 1 or 2 more questions?
It's okay, very well.
Okay.
All right.
So the next question is asking that can you join, if an action is brought against a financial institution, can they apply to join the person who was responsible? That's in this case now, the criminal. Can they apply to join the criminal in such a case? And what would be the outcome of such an application?
If they do, is it not better? Then your receipt-based claim is sure. Because first, but like I've said, you don't need the person. But if the person is joined, the better for you. So you have two persons to claim from. First, like I said, do not forget his bank may still have the money, in which case you go against the bank on a receipt-based claim. But if the money is not there, then of course, using a receipt-based claim to follow the money will not make any sense. What you will now do is to say that they have assisted a breach of trust because trust money came into their hand. And of course, they assisted the fellow who to breach a trust. So if you add the criminal to it, better for you. And if it's done by third-party proceedings, it means that the bank itself is saying, we're liable, but the person who should pay is this. Better for you.
Well, there's a question here that is very, very topical, and it talks about Bitcoins. It says, with the advent of Bitcoins and e-money, which has made fraudulent transfers of currencies untraceable, what remedies can one adopt in recovery where the monies are not in Bitcoin, or where the money are in Bitcoins?
Okay, if it's Bitcoins, do they still transact through banks? Certainly not, but they have intermediaries. So you can bring an action against those intermediaries.
Sometimes the intermediaries are not traceable.
Well, and who is traceable?
That's a challenge.
Who is traceable? So if there is some regulatory institution, because knowing receipt and knowing assistance basically are weapons against persons who are seen and known, who are solvent and doing business. But if there's no identity of a person who has assisted in the crime or who has received, then of course that will be the end of it. Evaporates. The remedy evaporates. The remedy cannot be in thin air.
So in effect, if you cannot trace the intermediary, then there is really no remedy.
Because our remedies of accessory is actually a remedy against the intermediary, not against even the fraudulent person.
Okay. Prof, the next question is asking, said, does exclusive clauses on bank mandate forms not exclude banks from any of these remedies, especially when monies are lost in account of customers missing ATM cards?
Thank you. I think we all need to read the case of Henderson and Mary Syndicate. That was a case where some guy left some money with stockbroker who had an exclusion clause in the agreement, and the exclusion clause says that they will not hold the bank responsible for anything. Of course, they launched an attack using contracts, and the financial house said, there's an exclusion clause. They changed the counts to torts and said, on that tort, you must exercise due care and skill, and that they did not exercise due care and skill. The guys fought the tort. They now took it back to equity, and they said that, look, because you know so much about monies, and we don't know that much, and we trust you, that makes you a fiduciary, and therefore you must use the principles of fiduciary law. And the House of Law said yes. So you could move from contract to torts, from torts to fiduciary, from fiduciary to restitution. So it doesn't stop anything. Those clauses, and if you look at the case of Scrutons or something, I can't remember, one of those old cases with torts. I think I did my contract law in 1980. When those clauses are so small and printed in those things, the court says that they are not, of course, those exclusion clauses do not cover the banks. And even if it covers the banks, it does not exclude liability in torts, does not exclude liability in equity, does not exclude liability in restitution. Because restitution actually takes place outside contracts.
Thank you, Prof. There's a question here that I'm sure would interest you.
Yes.
The person is asking, says, can we also adopt these recovery measures for funds stolen by our politicians?
Oh, very well. In fact, just read the case of Republic of Haiti against Davila. and read the case of Barbanet. I can send those things to you. You can read them up. There have been cases where tracing has been the government. In fact, I've always said that we don't even need any criminal proceeding against corrupt government officials. We can just go straight against the banks. And once we recover from all the banks will now be fighting the persons who are stealing government money. So if a man steals government money and puts it in a bank, why pursue the man? Just go to the bank, get the money removed from the bank, let the bank come under a liability that money is already spent. And let's say that he is a civil servant who earns 100,000 naira and he keeps in his bank account a balance of 100 million. Does that not itself show that the bank has willfully shut his eyes to see that which he should see if it's opened his eyes? It's very simple. So just go against the bank under an accessories liability claim. And once the bank pays the money, leave the criminal to enjoy his money. No bank will assist any criminal anymore.
Okay, so Prof, let's take this very last question.
Very well.
It says, in certain jurisdictions, example Nigeria, you have the NDIC. Banks by law are required to insure monies in their accounts to a certain limit. Can you also, after demanding the bank return amount required to be insured, still bring an action for the other amount not insured? So I guess what it's asking is that, can you, after you've demanded to the limit of the insurance, still take an action for the balance?
Yes, is what I say. That insurance is for bankruptcy of the bank, not for claims against the bank. Read the NDIC Acts. It's this, when the bank goes underground, this is what you will get. And even at that, I've always said that bankruptcy laws must be subject to rules of tracing. No Nigerian lawyer has tried it before.
Professor, thank you so much. It's been an enriching session. We apologize again for the challenges we had, and so sorry for the technical challenges you also had at your own end. We look forward to having you again on one of those sessions. It's been wonderful. For the cases mentioned, I know that a lot of people are wondering how they will get this. Like I said, we are going to email it to you at the end of the session. Well, thank you for attending this webinar, and we look forward to seeing you in the other session. Thank you very much, and have a wonderful day.
Thank you very much.
Bye-bye, everybody.
Thank you, Raf. Thank you, DF Legal, and thank you all my colleagues. Wonderful day to be with you. Have a nice day.
You too, sir. Bye-bye.
Madam, thank you.